Good morning, sir. Can you see and hear us?
Yeah, thank you very much.
Thank you. In a moment, I'm going to call Mr. Altman, King's Counsel. Before I do so, I should say, because it's a Wednesday, there's a fire drill at 10 a.m., and so the feed will be cut for those that are following online.
All right, that's fine.
We'll all remain in the room.
Yeah.
Thank you. Yes, Mr. Altman, then, please.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Altman. As you know, my name is Jason Beer, and I ask questions on behalf of the inquiry. Can you give us your full name, please?
Brian Altman.
You should have in front of you a witness statement with the URN WITN 10350100, which is 48 pages in length. Can you turn to the last page, please, page 48?
Yes.
Is that your signature?
It is.
And are the contents of it true to the best of your knowledge and belief?
They are.
Thank you very much for providing the witness statement. A copy of that will go up online on the inquiry's website. I'm not going to ask you questions about every part of it. Can I start, please, with your background? I think it's right that you were called to the bar in 1981. You took silk in 2008. You served as Treasury Counsel between 1997 and 2013, the last 3 years of which you served as first senior Treasury Counsel.
Yes.
The material times we're concerned with practice principally in criminal law, is that right?
Yes.
Thank you. Can I start, please, with the general approach that you took to the work that you did on behalf of the Post Office and your understanding of what they wanted from you? I think you ceased to be first Treasury Counsel at the end of June 2013, is that right?
Yes.
And you were instructed first by the Post Office the very next month in July.
That's correct.
When you were instructed, were you conscious then and afterwards that the Post Office wished to trade on your former status as first senior Treasury Counsel?
I wasn't conscious of it, but I suppose I would say it didn't surprise me that they came to somebody with that history.
It didn't surprise you?
No.
Was there anything more than that?
No one ever said to me that we are instructing you because of your professional history.
Can we look at some documents that
yes,
touch on this, please? This issue, please. They come up on the screen. Poll 00192287. And the page 2, please, at the bottom. Thank you. This is an email chain that you're not party to. It's not to you, it's about you. And you'll see that it's dated the 18th of July 2013 between Gavin Matthews and the people set out on that distribution list. He was a partner at Bond Dickinson, who was then to instruct you.
Yes.
And he says to Susan Crichton, then General Counsel at the Post Office, here's a list of possible candidates. And you'll see, I think, Mark Ellison in a link on that web page, Ian Winter at Cloth Fair Chambers, you at 2 Bedford Row, Nick Purnell at Cloth Fair Chambers, and then a couple of others whose names aren't revealed by the URNs. I'll skip over the next paragraph, the from speaking to colleagues. It says, in the following paragraph, Brian Altman QC is interesting in that he is first Treasury Counsel, though his practice is not big on fraud cases. Simon Richardson, one of the solicitors, points out the possible attraction politically of having first Treasury Counsel on board. And then if we scroll up, please. Keep going. And keep going. And then just stop there. Gavin Matthews says he's spoken to the various clerks. and then under 2 Bedford Row, that's you. And then if we scroll down, please. There, at the top of the page, it says he, that's you, is no longer First Treasury Counsel from 1st of July, but he has the ear of the Director of Public Prosecution stroke Attorney General's office. And then at the top of the page, if we keep going, please. There, stop. Mr. Flemington, one of the lawyers, says, how long is a few weeks in Brian's case? That's, I think, how long you're away for. And then his connections sound useful. Did anyone communicate to you upon instruction or otherwise that an attraction of having you as counsel would have a political dimension to it, in particular because you had the ear of the DPP or AG's office?
Never.
Were there any conversations that you had upon instruction or otherwise in which such sentiments were revealed to you?
Not once that I recall, no.
Would you understand why a client in the position of the Post Office in mid-2013, reviewing its past disclosure in criminal proceedings and possible miscarriages of justice, would see a political attraction of having you as its counsel?
No. I see the attraction of having me from a legal perspective as their counsel, but not politically.
A legal perspective because you are a very experienced prosecutor.
Yes.
Can you understand what they're talking about here at all? Your connections, your having the ear of the AG's office.
Well, I can see immediately from that email it was not me who made that representation, but I can see probably it was that attracted them.
You can see that what a belief that you had connections may have attracted them.
Oh, yes.
Did you ever use any such connections?
No.
Were you ever asked to use such connections?
Absolutely not.
Why do you think you can see why they would think that you having political connections would be useful?
I can't answer that, Mr. Beer, because I don't know what was in their mind, other than they may have thought that having somebody like me on the Post Office side instructed by them might give them some leverage in the political arena, but they were totally wrong if they did.
Thank you, that can come down. Can we look, please, at poll 406802? This is your review. It's an advice, but it's badged up in the tramlines as a review of the 19th of December 2013. And essentially, we're going to look at the detail later, but in summary, it consists of a review of the Post Office's investigatory and prosecutorial functions.
Yes.
And in particular, by looking backwards, advising the Post Office as to the continuation or non-continuation of those functions. Can we just look at page 40, please? And scroll down. And keep going and keep going. Thank you. Where you sign it off, do you see that?
Yes.
Against your name and your chambers is footnote 33. And footnote 33 takes us down to the foot of the page, where it says that you're a practicing barrister. You were first appointed first senior Treasury Counsel to the Crown at the Central Criminal Court by the Attorney General in December 2010. You remained in post until the end of your tenure in June 2013, appointed junior Treasury Counsel in 1997, and senior Treasury Counsel in 2002, appointed a recorder of the Crown Court in 2003, Queen's Counsel in 2008, and were made a bencher of the Middle Temple in 2010. And then there's a link to your Chamber's web page. We asked you when you were preparing your witness statement whether this was your usual practice to footnote your name or some other part of written advices and set out a mini career history, and you said it wasn't your practice to do that, and you couldn't recall why you did it on this occasion.
I can't.
Correct. Can I suggest some possibilities. Was it that you knew or believed that your advice might be deployed outside the organisation?
I mean, I've thought about this because I was asked the question, and the interesting thing is there's an absence of a biography like this on the General Review.
Yes. I think I understand the point you're making there. You're saying if there was going to be a document that was to be deployed outside the organisation, it would be more likely to be the General Review.
Exactly. The only thing I can think of, but this is purely speculative, is that I was told or understood that this document would go to the board. But whether I was ever told there was a possibility this review would go outside the organisation, I can't say.
And if you were told that the documents would or might go to the board, why would that lead you to emphasising these points as you do in footnote 33?
Well, all I can imagine is that I was either asked or I felt it was appropriate for the board to know who was giving the advice, because the advice in this review was not all one way. One of the points I made, having trawled through all of the policies that Post Office and Royal Mail had before Post Office, or at the same time as Post Office, were that they were in a parlous, unsatisfactory state of affairs. So that could have been my thinking, but I'm speculating.
The essence of the advice that you gave was that the Post Office could properly carry on investigating and prosecuting crime on its own behalf.
On what I understood at that time, yes.
Did you think that overall conclusion might be deployed either outside the organisation or to the board, and therefore you needed to emphasise how senior and experienced you were?
Well, again, one of the thoughts I've had is they must have known who they were instructing anyway, so this was just, if you like, telling them what they already knew.
Yes, because we're 5 months in now.
Yeah. But I agree. I don't know the answers to that.
So for you, this is a curiosity too?
I can't remember. I mean, we're going back over a decade, and I can't remember, and I'm not going to say I was asked or if I felt it was a good idea to do it, or somewhere in between. I just don't know anymore.
Can we turn, please, to poll 0021 4820? And this is an exchange of emails, again, to which you were not party, in December 2014, so a couple of years further on. And the exchange is about what to say and what not to say to Nick Wallace in answer to questions that he was asking for the proposed broadcast of a second one-show piece. And can we go to page 4, please? At the foot of the page, please. Thank you. His question is at 6. We would like to put to you some opinion about the Post Office's approach to investigating and prosecuting sub-postmasters. We're in possession of an expert opinion from a professor in criminal justice, which implies Post Office's dual function as an investigator and prosecutor and its 300-year cultural history of using it against its agents is unique. That's not to say he thinks you're the only organisation with prosecuting powers, but you have a unique culture of prosecuting your agents. He implies the approach lacks the checks and balances of a typical prosecution by the CPS. In his opinion, this creates a situation where miscarriages of justice are more likely to occur. I'll stop there.
Attention, please. Attention.
Thank you. Could I just check that you're still online, sir, and you can see and hear us?
Yes, I can. Thank you.
Thank you very much. Mr. Altman, I read the question, the Nick Wallace question, and then the answer, and I believe this is written in by Roderick Williams, one of the Post Office litigation lawyers. He says we should ask for this opinion. The privilege over it could have been waived. The expert cannot comment on what our culture is, at least not without speaking to us first. If this expert believes miscarriages of justice are likely to occur, he should set out for us the how and why. so that we can be sure they don't. Justice demands that. And then this, we've consulted former first Senior Treasury Counsel Brian Altman in connection with our prosecution practices. Brian's advice is privileged, and we cannot do anything which might waive that privilege. Please, therefore, do not do anything referencing Brian without clearing it with legal first. We've let Brian know that we may want to name check him, and this was contemplated when he was instructed. So two questions arising from that. Is it right that when you were instructed, you were told that you might, to use these words, be name-checked?
If I was, I've long forgotten it.
I.e. that your name might be deployed?
Yeah, I have absolutely no recollection of that.
And then later on, by December 2014, can you recall again being told that the Post Office, may want to deploy your name to the BBC?
I don't. I have absolutely no recollection of that either.
Was this an issue that ever arose to your recollection, that we want to say we, the Post Office, have got Brian Altman on board? He was first Senior Treasury Counsel. You can be assured that we're doing the right thing.
No, well, as I sit here now, I have absolutely no recollection of that.
Can we go forwards, please, to poll 0029 7951? We're going back to the time of your instruction. This is an exchange between Andrew Parsons, then a senior associate at Bond Dickinson, to Roderick Williams in the Post Office, a lawyer, and Gavin Matthews, the partner, with you as its subject heading. I think this is after you had given them the short, I think your clerk, John Grimmer, put it as a 20-minute freebie.
I can't remember the 20-minute freebie, to be frank with you, but the email I seem to recall was dated the 18th of July, so this is a few days afterwards.
In short, Brian looks like the right man for the job. In my view, he was very impressive. He's clearly taken this type of exercise before and is very live to the political dimension. Again, were you made aware that your client believed that there was a political dimension to the issues that the Post Office was facing?
Well, if that line in this email is accurate, then clearly I must have been. But what it was, particularly at that time, I can't tell you.
Was this political dimension described to you?
Well, as I say, Mr. Bear, I can't remember. If the email is accurate, maybe something was said about it, but I can't remember what that was.
They seem to think that you were very alive to it, the political dimension.
Well, everybody probably at that time who read anything about Post Office was probably alive to the political dimension. I don't think I had any unique insight into it.
What would you understand the political dimension to have been in mid-2013?
Well, again, speculating, because I can't remember this. It would inevitably be the fact that Post Office was, in effect, a government-owned organisation. And clearly the balloon was going up in respect of what had happened during the course of past convictions.
Mr. Parsons carries on. Big question. Is Brian's work private advice for the Post Office or an independent assessment of the Post Office's criminal law position? One for us to think about. Do you understand the distinction between those two species of instruction?
Absolutely.
Of those two, well, firstly, could you explain what you understand the distinction to be?
Well, private advice is advisory work to the client, which is privileged, and an independent assessment of Post Office's criminal law position, with the emphasis on the word independent, would be something that might be published.
How was the instruction first presented to you on those two alternatives?
Mr. Beer, like me, you will know that the terms of reference went through so many drafts, and frankly, when I saw them, for the purposes of making my statements, I couldn't sort out one from the other with any great ease. But I have to say, at no time did I ever understand that this was going to be some publishable independent review. And I think, unless you correct me, that all of the terms of reference, in fact all of the drafts, were always couched in terms of non-publishability. And that was always my understanding. And you'll note what I said in my witness statement, that when I did come to write the general review, it was headed legally, professionally privileged. I set out all the terms of reference, which included its non-publishable nature, and also that it was clear to me that this was advisory in nature and not an independent investigation.
So of those two species of instruction set out there, you understood this to be client advice in the ordinary sense?
Yeah, private.
And you were not being asked to conduct a public or independent review of the Post Office's prosecutorial investigatory practices or its past prosecutions?
No time.
If the latter had been the case, that you were instructed to conduct an independent assessment of the Post Office's criminal law position as it's put out there, how would you have approached your task differently?
I might have asked for more assistance than I had. So I might certainly have suggested that it would have to be far more wide-ranging and searching if it was in the nature of a proper investigation rather than advisory. And so I would have almost certainly said I wanted resources. Terms of reference might have been different because in the nature of even a non-statutory inquiry or an investigation, you want to think about procedural fairness to people who might be criticised in the course of a publishable document. So all of those things I would have thought about, and I think my approach to it would have been very different.
So your instructions, your terms of reference would have been different, your approach would have been different, the resources that you would have asked for would have been different, and presumably your relationship with your client would have been different.
Yes, I mean the whole thing, the whole approach would have been entirely different. I would have kept them at arm's length, and I think it would have taken a substantial period of time, longer than it actually did, although the general review took, as you can imagine, a long time to put together without any assistance. I'm not criticising, but that's the fact. But it would have taken much, much longer to perform a proper independent investigation, of which, since that time, I have experience.
Later in the piece, the inquiry is aware that the Post Office came to rely on the work that you did do as having given the reviews conducted by Cartwright King great or greater credibility.
Yeah.
Were you aware when you were instructed that that might occur or was to occur?
Forgive me for asking, do you mean within the organisation or outside the organisation?
Outside the organisation. To, for example, the CCRC. Essentially, and I'm summarising greatly here, you can trust the reliability and integrity of what we've done in reviewing our past convictions. After all, we've got First Senior Treasury Counsel reviewing the work of Cartwright King.
Well, I think I was aware that the Post Office was either likely to do that or had to do it. I know I was privy, I think, to some of the correspondence that went to the CCRC. But yes, I suppose I was alive to that possibility.
And so in that sense, the Post Office was treating your work as falling between two stools. It was private work, enjoying privileged, but the existence of which was relied on for benefits when deployed outside the organisation.
Yeah, I suppose you could say that.
So they kept your advice private, but used your name to, would you agree, bolster the integrity of what they were doing?
That's a possible inference.
After receiving these instructions to, this can come down, sorry, after receiving these instructions to advise the Post Office, were you advising as a prosecutor briefed by a prosecuting authority or as a member of the independent bar with considerable prosecution experience advising a commercial entity?
Principally the latter, but not forgetting the former.
And why do you say it was principally the latter, advising a commercial entity
Because
that happened to prosecute people?
Yeah, well, because Post Office is or was a private prosecutor. But at the same time, because of my history and my experience, you have to always have in mind that even a private prosecutor has to act as a minister of justice and act with fairness. And I made that clear, I hope, pretty early on. And so I always had in mind all of the principles which I was very much alive to in advising them.
In that calculus, did you bring into account the fact that although the Post Office was a commercial entity, it could be seen as a public authority in that it was government-owned?
I think I was actually asked that question, and I'm struggling right now to remember where it is I confronted that issue. But I did. But at the same time, I don't think it made any real difference to my approach to the questions I was asked to answer.
And why was that?
Because at the end of the day, whether you're a private prosecutor or a public authority which prosecutes, the principles are the same.
Did you consider whether you were approaching the matter from the perspective of being the subject to the same ethical standards as if you had been asked to advise, say, the CPS?
Yeah, my ethics would never have changed.
This issue, the capacity in which you were advising, doesn't appear to be touched on in any of the advices, i.e. I'm advising you as a commercial entity, but the same applicable ethical standards apply. Was there a reason for that?
I can't say if there was a reason. I probably didn't even think it was necessary to have to spell out the precise capacity in which I was acting. But as I have said, I can remember very early on advising the Post Office of what its duties were and that it had to act with fairness.
Was there any shift in the basis on which you were instructed when you were instructed on behalf of the Post Office in the Court of Appeal, essentially to prosecute?
Any shift?
Yes, any difference?
None that I can think of, no.
Were you ever contacted by, or did you ever contact BTO, a firm of solicitors in Scotland, instructed to advise the Post Office in Scotland?
Not once.
Do you know whether your draft or final versions of your advices that were addressed to the Post Office were distributed to BTO solicitors in Scotland or to the Crown Office and Procurator Fiscal in Scotland?
I have absolutely no idea about that.
Was there any communication with you about the distribution north of the border of the advice that you were giving?
None that I recall.
Thank you. Can I turn to the second topic then, please? This is Mr. Clark, Simon Clark's advice of the 15th of July 2013 and the treatment of Gareth Jenkins. Now, I think you, as you've said already, you were asked for your views and observations on the terms of reference for your initial instruction, correct?
Yes.
And so you were asked to advise on what you should be asked to advise on.
Yep.
I've got that right, yes?
Yes.
Okay. Can we look, please, at poll 406804? And if we go to the final page, which is page 5, please, and scroll down a little, we'll see that this is your document, and it's signed off on the 2nd of August 2013. And so if we go back to the first page, please. So these are essentially your observations on the draft terms of reference, your instructions.
Yes.
Do you know why they weren't just called instructions if this was a straightforward client-barrister relationship giving private advice?
I suspect because they came from Bond Dickinson and the nature of that firm. They weren't a criminal firm, and I'm not even sure that Gavin Matthews, who was the principal point of contact, was a litigation lawyer.
Even in civil law, though, when barristers are instructed, they're normally called instructions.
You may be right, but I have to say I didn't see any substantive difference between the use of the terms of reference or instructions.
In any event, this is your advice on the things that you're asked
Yeah.
to advise on. And if we look, please, at page 3, under the heading Process, you say paragraph 2 of the process section of the overarching terms of reference includes the possibility of my meeting Dr. Jenkins. I note this is queried. Not meeting and hearing him, where there may be questions potentially impacting on non-disclosure by him and his role as an expert, risks exposing the final report to criticism. However, this is not a judicial or public inquiry with the formal receipt of evidence. This is something I shall need to think about carefully. At this very early stage, I'm not unnaturally undecided. For now, it may be better for the terms of reference to remain silent about him.
I think I say something more over the page as well about that.
Yeah. At all events, if we just go over the page, paragraph 3 is generally worded, covers it, as is acknowledged in para 2.3 of the covering email, and in my view should be the wording adopted for both the overarching and abbreviated terms of reference documents. In your witness statement, you say, and no need to turn it up, it's paragraph 21 on page 8, it's clear from this, and that's this document, that early on in my instruction, I did consider whether to meet Gareth Jenkins. I do not have a copy of the document I'm referring to here, which must be an earlier iteration of the draft terms of reference, and I do not know now what was queried, how it was queried, or by whom. In the event, I did not meet Gareth Jenkins, and I cannot find any record I had any further discussions about it, or any record of my reasoning for not doing so. If we go back a page, please, and scroll down. In that final paragraph on the page there, why were you concerned that not meeting or hearing from Mr. Jenkins would risk exposing your final report to criticism?
Well, I think it's in the first line where there may be questions potentially impacting on non-disclosure by him. And so I suspect I had in mind at that point the question, why was it that Gareth Jenkins, particularly in the Seema Misra case where he gave live evidence, had not disclosed what he knew about those 2 Horizon Online bugs. And so I suspect my thoughts at that time were targeted at that particular issue.
So I'm so sorry.
No, it's all right. But I suspect as time went on, I came to the conclusion that the reasons why he had not revealed those bugs in trials in which he had provided witness statements, or in Seema Misra's case in particular, where he'd given live evidence, was not ultimately material to the questions I was being asked to consider. It was the impact of that non-revelation on convictions that was what I was being asked to look at.
And Mr. Altman, I'm going to explore that distinction that you've just drawn.
Yeah.
That reasons irrelevant, impact important. Would it be, as you've written it here, that not meeting him would be turning a blind eye to a potentially useful source of information? That's why you wouldn't want to do it.
That's why I would or would not want to do it.
Would not want to do it.
If you're suggesting that I'm turning a blind eye, I was not turning any blind eye to anything.
You'd identified here that if you didn't meet him or didn't hear from him, it would expose your final report to criticism. In the event you didn't meet with Mr. Jenkins, did you?
No, I didn't.
But whilst we're on this point, why was the product of your instructions, your terms of reference, to be called a final report, rather than what we normally provide, which is advices and opinions?
It was just a use of words. I
Well,
think
does-
if you, I regard this as an advice. And in fact, the review document is referred to as a review, not a report.
You say it's not a judicial or public inquiry with the formal receipt of evidence, the thing that you were undertaking. Does that suggest that you thought that it was some form of inquiry, a private inquiry or a private review, rather than just client advice?
I think there is a mixing of terms here, but I have no doubt that I was being asked to give private advice to the post office.
In the last line, you say, for now it may be better for the terms of reference to remain silent about Mr. Jenkins. Why did you consider it best for the terms of reference to remain silent on Mr. Jenkins?
Because I hadn't resolved at that point whether I was going to see him.
That's a separate issue, isn't it? Whether or not you saw him, to whether or not the terms of reference should mention him.
Yeah, well, I think I see what you're driving at, but I just felt that we were debating, me and Gavin Matthews, as to what the terms of reference should be. So my view was, if I had not yet resolved to see him, then there was no point sticking it in the terms of reference, which were ultimately my instructions.
Had the centrality of Mr. Jenkins to the issues been communicated to you by this stage, August 2013?
Well, I'd clearly understood what had happened in the trials, and I'd clearly read the Clark advice.
And so it had either been communicated to you or you had by this time realised that he was a central figure.
I understood that.
Why wasn't there an investigation into how and why Mr. Jenkins came to give evidence that Mr. Clark had advised was misleading and a breach of his duties to the court?
Well, when you say an investigation, because I wasn't conducting an investigation, I was giving advice to the post office.
Why didn't you give advice that the post office should investigate why Mr. Jenkins had come to give evidence that was, according to Mr. Clark, misleading and in breach of his duties to the court?
Because I come back to what I had thought, that the advice I was giving was about the impact of that failure on the prosecutions and the convictions, not the reasons why he had failed to do it.
What did you know at this point about how Mr. Jenkins had been instructed?
Do you mean his instruction as an expert?
Yes.
I'm not sure I was told.
Did you ever ask for or review any instructions that he was given?
I can't remember having done so.
Did you ever appreciate the risk that Mr. Jenkins had himself been manipulated by the post office or misinstructed?
No. I assumed, because I was not told otherwise, that he'd been properly instructed throughout.
Did you check whether that was in fact the case?
There is nothing in the material I've seen to say that I did.
Did you check whether Cartwright King were going to address that issue, namely the proper instruction of Mr. Jenkins as an expert?
Address it with?
By examining the files or by speaking to Mr. Jenkins?
I can't remember if that was said or not.
As part of your assessment that we're going to come to in the general review later on, you say that Cartwright King's review was fundamentally sound.
The process, I felt, yes.
This issue, by removing him from the terms of reference, meant that the Gareth Jenkins issue remained shelved, didn't it? Never to be returned to.
Not during my review, no.
Did you ever get the sense that nobody in the post office, or indeed Cartwright King, wanted to look too deeply at how Gareth Jenkins had been instructed, and instead their better narrative was that he personally was to blame for disclosure failings?
I never thought that, and I never saw it, and doing the best I can, I don't think I ever heard it either.
Now, the document that you said in your witness statement that you hadn't got, the draft terms of reference upon which you were commenting, can we look at those, please? I think they are Poll 0029 8010. These are dated the 26th of July 2013 and are prepared by Bond Dickinson, as we can see in the top right. And so these are the draft terms of reference. And if we just pan out a little bit, please. You can see they're divided into instructions, process, output, and then over the pages, timing. And just on instructions,
Well, pausing there, Mr. Beard, you made the point before that the word instructions wasn't used. It is.
under the heading of terms of reference.
Yeah. But the fact is the word instructions is to be found there.
One, to review and advise the Post Office in a written report on its strategy and process for reviewing past and current criminal prosecutions given the findings of the Second Sight Interim report dated the 8th of July 2013. Secondly, to advise the Post Office on its response to the CCRC and any subsequent action required in dealing or responding to any actual potential appeals. 3, to advise the Post Office, where not covered by one above, on the role of Dr. Gareth Jenkins and the impact on possible appeals. And so Bond Dickinson had included, as we see, instructions to advise on the role of Gareth Jenkins and the impact on possible appeals, yes?
Yep.
And then under process, if we scroll down a little bit, under 2, to meet with John L. Singh and Cartwright King, and then in brackets, Dr. Jenkins, question mark, to understand the past and current procedure for prosecutions.
Sorry, Mr. Beard, I heard you name John L. Singh. Where do I find that?
Under 2.
Under output or under... Oh, sorry,
Under process, yeah, to meet with John L. Singh
Yep.
and Cartwright King
Yep.
and query Dr.
Yes.
Jenkins.
Well, that was a query I must have had in mind.
So your draft terms of reference did include, as one of the 5 things that you were asked to do, explicitly to advise on the role of Gareth Jenkins and its impact on possible appeals.
Yep.
Yes? Why did you consider it wasn't appropriate to advise the Post Office on the role of Gareth Jenkins? Why did you, if we scroll up please, suggest that paragraph 3 was removed?
Forgive me, paragraph 3 under instructions.
Yes.
Well, I haven't seen this and I didn't recall advising that it was that paragraph that came out, because I did advise on Gareth Jenkins, the role and the impact on possible appeals.
But you said, we've seen your advice, that these terms of reference should remain silent on Gareth Jenkins. So why should Gareth Jenkins be excised from the terms of reference? Why should he be cut out?
Well, I mean, he wasn't cut out because I did advise about his impact, and I think I come back to the answer I gave earlier, that I felt the reasons why he had failed as an expert to discharge his duties of disclosure was not what I was being asked to advise upon. It was the impact And
But
that's what I
you
did.
were given the opportunity
Yeah,
to
absolutely.
self-define what you were being asked to
No,
advise on.
You're right, I was, and that's the only answer I can give you. That must have been my thought process.
But why at this very early stage were you putting out of reach the possibility of an exploration of Mr. Jenkins' role?
I think my answer has to be the same. I was looking at the impact I felt. By the time I got to agreeing the final terms of reference, that was what was in my mind. I didn't feel, I suppose, partly speculating, it was because I did not feel I was an investigator at this stage. It was simply gathering information and writing an advice on the impact.
Weren't you not loading the dice by excising him in this way?
I don't see it that way.
Now, if we look at the final version of the terms of reference, the one that was settled after your advice, poll 304 0044. These are the settled terms of reference for your appointment. And if we just look, if we scroll down gently, thank you. We can see that Mr. Jenkins' role, and indeed any reference to him, has been entirely cut out from these terms of reference, hasn't it?
Yes.
Can I turn to what you say in your witness statement about this? If we turn it up, please.
What paragraph is it?
It's paragraph 26.5 on page 30. And in the third line, you say why Mr. Jenkins had failed to reveal in his witness statements or evidence the bugs or defects he knew about was not a matter for my review. Yes? That's because you cut it out.
Absolutely.
You're explaining in this paragraph a later aspect of your instructions, and you're explaining to us why your reviews didn't address the issue of why Mr. Jenkins had failed to reveal in his witness statements or evidence the bugs or defects that he knew about. And you say it's not a matter for my review. But again, that's because it was your choice to exclude it, wasn't it?
It was excluded. I don't know what discussions I had with Gavin Matthews. I don't know what my thought processes were between the July version of the draft and the final September version of the terms of reference, other than what I said in the observations document.
Doesn't the approach that you took rather ignore the point that the reason for Mr. Jenkins' failures might well be relevant to whether or in which cases they were disclosable?
I'm not sure that's right, actually, Mr. Beer.
And explain why.
Because what he said about individual cases, I don't think would necessarily make a difference if he had not understood his duties as an expert, and as Simon Clark pointed out, was by and large making the same statements in every case. Then, generically, I think his failures fell for disclosure. I don't think asking him about every single case in which he made a statement and the whys and wherefores would necessarily impact, as perhaps you think it would, on disclosure.
If the failures arose from a failure by the post office to A, provide Mr. Jenkins with a proper letter of instruction, B, instruct Mr. Jenkins as to his relevant duties as an expert witness, those failures would be disclosable too, over and above the mere fact of his own failure to disclose knowledge of bugs, errors and defects, wouldn't they?
I agree with that, but they are generic issues of disclosure, not case-specific.
And therefore require to be investigated, don't they?
Well, if that was right, and obviously I didn't know that, but if that was right, they would be disclosable, but I don't think they need to be investigated.
How would you discover whether that was the fact?
Well, if somebody had told me.
But you cut it out, haven't you? You've
Yeah,
excised it.
I know, but it's slightly circular, because if somebody had told me he'd never been properly instructed, I might have taken a different view.
Can we move on, please, to your generic review, please? Poll 406803. This is your general review dated the 15th of October 2013, and this is the main product of your terms of reference, as they've been called, yes?
Yep.
I.e. the terms of reference we've just looked at.
Yes.
And can we look at a part of it, please, on page 47? And paragraph 148. But I should have introduced this a bit more broadly to you. If we go back to page 44.
Page 44.
Yes. Under the heading Gareth Jenkins and his impact on possible appeals. It's within that section. If we go forwards, please, to paragraph 148 on page 47. You say, I'm not clear whether Mr. Jenkins was challenged about the non-disclosure to the post office. That's the non-disclosure of a bug. And if so, what is the explanation for it? But given the second site inquiry, based in part on his relations, has led to the current review, Gareth Jenkins is to that extent tainted, and his future role as an expert is untenable. It should be remembered that the post office had been unaware of the existence of the second of the two defects revealed to second site by Mr. Jenkins until a year after its first occurrence. Before writing this, did you inquire as to the reason for Mr. Jenkins' non-disclosure?
You can read that first sentence in one of two ways. I either did and wasn't clear about it, or I didn't and I wasn't clear about it.
Did you see any post office instructions to Mr. Jenkins in his role as a witness giving expert evidence in prosecutions, or correspondence involving the post office legal department or post office external lawyers regarding Mr. Jenkins giving evidence in legal proceedings?
Again, as I sit here now, I've got no recollection of that.
If you didn't see such instructions to Mr. Jenkins, and I've no material to suggest that you did, why did you not ask to see them to inform your work?
You know, with the clarity of hindsight, Mr. Beer, we can all do things better, and that's something that I could have done better, but I didn't.
You were working, I think, on the basis that Mr. Jenkins knew about the receipts and payments mismatch bug, and that he had first revealed it to Second Sight in the course of their investigations in 2013. Yes?
Yep.
You did not discover, and you were not told, that he'd in fact disclosed the existence of the receipts and payments mismatch bug to the Post Office IT team and an operational team in late September 2010.
You're talking about the issues notes?
Yes.
I didn't know that.
You didn't know that he had written the report, the lost discrepancies document of the 29th of September, and that had been sent to a post office investigator, Alan Simpson, and indeed sent on to lawyers, Rob Wilson, Juliet McFarlane and Jarnell Singh. You didn't know about that at the time you were writing?
No, not only that, but I seem to recall that when the second site report dealt with the receipts and payments mismatch bug, it reported that Post Office didn't know about it until 2011.
Yes.
Yeah. No, I didn't know about it.
You didn't know that through Mr. Jenkins, disclosure of the receipts and payments mismatch bug had been provided to the Post Office the working day before Seema Misra's trial started.
I've learned that obviously since, but I didn't know it at this time.
All of that would have put an entirely different complexion on the advice that you were giving, wouldn't it?
I accept that.
And just explain why you accept that it would have put an entirely different complexion on matters.
Well, because if I had known about the issues notes and the other document, the correcting accounting for discrepancies document, all of which came into being, as you say, very shortly before Mrs. Misra was tried in October 2010, I suspect I would have taken the same view as we took much later during the criminal appeals, that is something that should have been considered for disclosure and disclosed to Mrs. Misra before her trial.
Did you give any consideration to the procedure by which the expert witness, Mr. Jenkins, had been instructed?
Well, as I've said, Mr. Beer, nobody indicated to me he'd never been properly instructed. Looking back, of course, it's something I should have queried, but I rather blindly, I suspect, assumed that must have been the case.
And so I think you agree that it would have been responsible to recommend to the Post Office that the issue of how evidence from Mr. Jenkins had been obtained was looked into.
It would have been responsible for the Post Office and those instructing me to let me know. I think it would have been, in my case, better to have asked, yes.
On this topic, were you aware that the Post Office did not escalate Mr. Clark's advice, the 15th of July 2013 advice, about Gareth Jenkins
Escalated
to Fujitsu?
I wasn't aware of what was going on in the background.
So you didn't know one way or the other?
I don't think I did.
Thank you. That can come down. I think it follows that you weren't informed at the time that you were advising the Post Office that it was known to the Post Office that Mr. Jenkins either hadn't been properly instructed or may not have been properly instructed as to the duties owed by a person giving expert evidence to a criminal court.
Yes, I should have known that.
Or at least that there was a very serious question as to this.
Yes.
We've got some manuscript notes of a discussion held between lawyers in September 2013 about that issue, whether Mr. Jenkins had been properly instructed and that it appeared that he may not have been properly instructed. That discussion between lawyers, it was Roderick Williams and Martin Smith, that was not revealed to you.
Did you say September?
Yes, 2nd of September.
No.
Do you agree that you ought to have been informed of this, a realisation amongst some of the lawyers that Mr. Jenkins had not been properly instructed, or that there was a serious question as to whether he had?
Yes.
And is that because the issue went to whether it might be indicative of broader failings on the part of Post Office prosecutors?
It would certainly have gone to that issue, yes.
It might be relevant to the scope of disclosure that needed to be given.
Yes. And also, I suppose it's easy for me to say now, it may have changed my view about what to do about the Jenkins problem.
What do you mean it might have changed your view?
Well, I might have come back and said, well, perhaps now I ought to speak to him and find out what was really going on.
Or call for any papers that go to the issue of the instruction of Gareth Jenkins?
Or the absence of them, a surge. I don't know, but that's what probably would have happened.
But it might have gone to the issue of whether there were broader failings on the part of Cartwright King.
Yes.
And whether there was a conflict, accordingly, in Cartwright King advising on its own cases.
No, it's an interesting take on it, Mr. Beer, but yes, I suppose that's right.
Well, it's not only interesting, it would be a matter that would concern you, wouldn't it? If this train of inquiry had been pursued, if this thread had been pulled, i.e. who has instructed Gareth Jenkins and how, that may have been revelatory of disclosure failings, but also of misconduct by prosecutors, mightn't it?
Potentially.
It goes to the issue of how deep into the organisation and how close to the lawyers the problem is, doesn't it?
I agree.
I think you're now aware that not only was Mr. Jenkins not instructed as to his expert duties, but the inquiry has seen evidence in a series of communications that prosecutors actually misstated the nature of an expert's duties.
I'm not sure I am aware of that. Well, certainly, I'm aware of the former. I'm not sure I'm aware of the latter.
For example, he was asked, he sent an email to a lawyer saying, what do I expect when I give evidence? And
well,
he was told, like any other witness, you've just got to tell the truth in relation to questions asked of you.
Well, forgive me if I've missed it, because I was sent an awful lot of documents over the past 7 days. But if I'm aware now, but I'm not sure I was aware of that.
And he was told, you can only be asked questions about issues that you've addressed in your report. You can't be asked questions about things that aren't addressed in your report.
I didn't know that.
But the Post Office never volunteered to you that it hadn't instructed Mr. Jenkins as to his expert duties.
No.
And did it provide any email communications which Mr. Singh had with Mr. Jenkins?
Sorry, ask that again, Mr.
Yes. Did the Post Office provide you with email communications between Mr. Jenkins and Mr. Singh, in particular in the course of the Seema Misra trial?
You mean after my instruction in 2013?
Yes.
I can't remember.
Were you told about the process by which the so-called generic statement written by Mr. Jenkins came to be created?
No.
Is it the case that you became aware that there were serious issues as to the use made by the Post Office of Mr. Jenkins and their instruction of him in the course of the criminal appeals?
I learned a lot then, which I was unaware of previously.
And so I think it follows that no one informed you at the time of your 2013 advices that Mr. Singh, Julia McFarlane, another lawyer in Post Office Legal, and Rob Wilson were provided with the 2 detailed notes about the receipts and payments mismatch bug.
No.
And that whether by inaction or by a positive decision, those documents were not disclosed into Seema Misra's trial.
Well, obviously, I didn't prosecute Mrs. Misra. There is any number of reasons why that might have happened, but it didn't happen.
Were you told at the time of advising in 2013 that people that were called senior stakeholders within the Post Office had been informed of the receipts and payments mismatch bug in November 2010 and had been informed by a note about the receipts and payments mismatch bug?
Who do you mean by senior stakeholders?
Well, if we look at the document, poll 0029 4684. So you'll see this is an email of the 15th of November 2010.
Yeah.
The subject is a receipts and payments resolution proposal meeting. I think it's an invitation. You'll see there's a list of required attendees and optional attendees, and a note is attached. And then if we scroll down, please. Thank you. The aim of the meeting is to discuss the working group proposal to resolve discrepancies generated by branches following a specific process during completion of the trading statement. And if you just scan the next few paragraphs.
Do you want me to read those, Mr.
Yes,
Beer?
please.
Yeah.
And then if we go over the page, please. So just look at the foot of the previous page. There are several solutions to resolve the issue at the affected branches. They are as follows. Now, if we scroll down. Solution 1, 2, 3. You probably recognise those.
I do, yeah.
Because they're from the notes of late September, early October 2010,
Yes.
where there was a discussion over which of these three solutions to adopt. And I think you recognised subsequently that solution 1 was a very significant one, not only for the receipts and payments mismatch bug, but because it revealed that Fujitsu had the ability manually to write entry values into the local branch account without the sub-postmaster knowing. Is that right?
I think so, yeah.
So it seems on the 15th of November 2010 that this is still an open discussion about which solution to adopt. And then if we scroll down, please. At the foot of the page, it says, "We are looking for you as senior stakeholders to agree this approach as a way forwards." So the point I'm making is that there had been some non-disclosure in Seema Misra's case before trial, and then afterwards there was still a discussion going on in November 2010 within senior stakeholders of the Post Office as to the receipts and payments mismatch bug.
Yeah.
This is all. This would all be news to you, advising in 2013, because you were under the impression that the receipts and payments mismatch bug had been discovered by Second Sight.
Second Sight on the information of Gareth Jenkins.
Yes. And so you didn't know when you were advising how high up in the Post Office knowledge of the receipts and payments mismatch bug had gone.
I knew none of this at that time.
Can we look at the time, closer to the time that you were advising them, please? Poll 0002 9618. And if we scroll down, please, and keep going, and keep going. Thank you. An email of the 25th of June from Mr. Warmington of Second Sight to Simon Baker within the Post Office, giving an extract from the draft Second Sight report. This is the draft section of the report dealing with the two defects. Please let me know if I've got anything wrong.
Sorry, I'm just trying to pick up where you found that.
Yeah. So where it says, Simon, this is the draft section of the report dealing with the two
Please
defects.
let me know, yes, sorry.
Please let me know if I've got anything wrong. Yes?
Yep.
And so he is sending a draft section of the Second Sight report that deals with the two bugs, yes? And then if we scroll up, please. A reply from Mr. Baker, I'll need to double check a few things. And then keep going up, please. Stop there. Mr. Baker, seemingly to Leslie Sewell, says, Josh got this from wrong. I can get back to him on most of the questions, but need your help on who in Post Office knew about it. I know from the email that Rod sent that Mike Young knew, but don't know if it went any higher. So within Post Office, a discussion of how high up within the organisation knowledge of the receipts and payments mismatch bug went. And then scroll up, please. Leslie Saul, the Chief Information Officer, replies, copying in the company secretary, I don't know if it went any higher than Mike. Andy Mook also managed service at the time. And if I remember correctly, Mark Burley was also involved. Can't recall whether we said anything to the press. And we didn't have an independent board. Paula Venables would have been network director. So there was an internal discussion proximately to the time that you were being instructed as to how high up within the organisation knowledge of the receipts and payments mismatch bug went, yes?
Yeah. I mean, I never saw any of this.
No, I'm about to say.
Yeah.
The fact of the knowledge of the receipts and payments mismatch bug by senior stakeholders was not revealed to you.
No.
The fact that lawyers responsible for prosecuting knew about the receipts and payments mismatch bug was not revealed to you.
No.
And the fact that proximately to the time that you were being instructed, the Post Office was having an internal debate about how high up within the organisation knowledge of the receipts and payments mismatch bug went was not revealed to you.
No.
When were you first made aware of the mismatch bug?
In the the RPM, the receipts and payments mismatch bug, you mean?
Yes.
When I read the second sight interim report. The 8th of July one.
And when did you first see an RPM, as you call it, document referring to the three options?
I first actually saw the reference to those three solutions, if my memory serves me, in Mr. Justice Fraser's judgment on the Horizon Issues trial.
So after December 2019?
Yeah.
Or in or after December 2019?
Yeah. Although, not to be unfair to Post Office, one of the documents I was asked to look at, one of the additional documents, which I hadn't seen before, was an index to the bundle of the material which Roderick Williams sent to me for the purposes of the 2016 review. And under the second section, in relation to balancing transactions, was reference to the issues notes and the correcting discrepancies document. But I don't think I ever opened up that part of the bundle, because you'll recall Roderick Williams and I agreed in 2016 that I wouldn't be advising on the balancing transactions issues because they were instructing Deloitte to finalise a report. So, not to be unfair to Post Office, it was there, but I don't think I ever saw it or read it in 2016. And frankly, if I did, whether I would have appreciated its impact, I'm not sure.
We saw that under Solution 1,
Yeah.
as well as obviously revealing the fact of the RPM bug, it also gave an insight into the facility for a form of remote access.
Yeah, can we go back to it, do you think?
Yes, I think so. Poll 0029 4684. Page 2. Solution 1.
Yes, thank you.
What were the implications for you that a form of remote access meaning that branch accounts could be changed without branch knowledge, either in error or by a malicious actor, meant to the prosecution of offences?
Well, as I say, I didn't actually see, in the sense of read the documents until we came to the criminal appeals, but it would have raised the possibility of unexplained shortfalls not being unexplained.
Was there anything, would it have revealed anything broader than that about the ability of a prosecutor to stand before a court?
I wouldn't say this is a real loss.
Yes.
Well, of course it would impact on that.
Sorry, I missed your answer.
Forgive me, of course it would impact on that.
And how would it impact and in what way?
Well, it would impact on any prosecution of the offence of theft. If you are trying to prove that there has been the permanent of the appropriation of money with the requisite intention, you would struggle if that was known. And sitting here thinking about it, it would probably also impact on potential allegations of false accounting as well.
And in what way in relation to false accounting?
Well, in the situation where a postmaster would offer the prosecution a plea to false accounting in consideration of the post office dropping theft, if a postmaster had known that this kind of activity had interfered with the branch accounts, then they might be pleading guilty on an entirely false basis, that any false accounting for which they felt they were responsible for or had almost certainly been responsible for might not be the case.
Thank you. So that's an appropriate moment to take a break, if it's convenient to you, until 11:15.
Yeah, certainly.
Thank you very much, sir. And having looked at what was cut out from your review in relation to Gareth Jenkins and what information was not revealed to you by the Post Office, can we look at what you did do on your more limited understanding or knowledge of the position in relation to Mr. Jenkins? Can we see, firstly, your general advice, please, your general review, poll 406803. Remembering this is your general review of the 15th of October 2013. And can we look at page 6, please?
Excuse me. Yeah.
And scroll down to paragraph 10, Roman 10. And this is essentially an executive summary
Yeah.
of the review. And in relation to Mr. Jenkins, you say, I agree that Gareth Jenkins is tainted and his position as an expert witness is untenable. Thus, a new expert should be identified as soon as is practicable. Yes?
Yeah.
Were you basing that view principally upon what you had read in Simon Clarke's advice of the 15th of July 2013?
Yes, I think that must be the case.
What was done to inform past defendants and those in ongoing cases that Mr. Jenkins had wrongly withheld knowledge about bugs in the Horizon system?
I know what you're driving at, Mr. Beer, and it's something in recent weeks which I have thought about, and it's something that should have been disclosed to appropriate people.
Is the answer then that nothing was done to inform convicted defendants or those in any ongoing cases that Mr. Jenkins had wrongly withheld his own knowledge of bugs in the Horizon system?
Yeah, I think unhappily that has to be the case. I mean, with the benefit of hindsight and having thought an awful lot about this, it's something that should have been considered for disclosure and disclosed in appropriate cases. No question.
And should have been considered for disclosure by you, Mr.
Yeah, I'm accepting that, yeah.
Thank you. Can we look at Mr. Clark's advice on Gareth Jenkins to see what he said? That's poll 406798. This is the advice of the 15th of July. We can see that from the last page, page 14. We just scroll down. So the Clark advice of the 15th of July about Gareth Jenkins. And you'd certainly got this, I think other material shows, by at least the 2nd of August.
Yes.
2013, so within a couple of weeks of it having been written. And then if we just look at what Mr. Clark had said by looking at page 5, at paragraph 15, he says, Gareth Jenkins has provided many expert statements in support of the Post Office and Royal Mail Group prosecutions. He's negotiated with and arrived at joint conclusions and joint reports with defence experts, and there's a cross-reference to Khayyam Ishaq's case there, footnote 7, and he's attended court so as to give evidence on oath in criminal trials. And then if we go forwards, please, to paragraph 37 on page 13. What does all this mean? It means that Gareth Jenkins has not complied with his duties to the court, the prosecution or the defence. The reasons why the 38 Gareth Jenkins failed to comply with this duty are beyond the scope of the review. The effects must be considered. I advise the following to be the position. Gareth Jenkins failed to disclose material known to him but which undermines his expert opinion. This failure is in plain breach of his duty as an expert witness. His credibility as an expert witness is fatally undermined. He shouldn't be asked to provide expert evidence in any prosecutions. Those current and ongoing cases where Gareth Jenkins has provided an expert witness statement, he should not be called upon to give that evidence. We should seek a different independent expert to fulfil that role. You agreed with those views, didn't you?
Yes.
Was the agreed position then that you and Mr. Clark had arrived at that Mr. Jenkins hadn't complied with his duties to the court, to the prosecution or the defence, that he was in plain breach of his duty as an expert witness, that his credibility as an expert was fatally undermined, to your knowledge, ever disclosed to past or current defendants?
At that time, no.
And just to be clear, we're not here referring to the fact of his knowledge of the bugs, errors and defects said to have been concealed by him, but rather an assessment by the prosecutor that his credibility had been fatally undermined. They're two different facets, do you agree?
They are, and I accept, as I've said already, that to my knowledge that was not disclosed.
Was there ever an investigation into whether others involved in the prosecution of sub-postmasters knew about bugs but had not disclosed them?
I'm just struggling to think about who you might mean, others
Well,
involved in
John L.
prosecution.
Singh, Mandy Talbot, Rob Wilson, a whole group of investigators who had knowledge of bugs.
Mandy Talbot, I'm not sure that's a name familiar with me. John L. Singh obviously is. And Rob Wilson, I never met, but I know the name. And forgive me, the question is whether it became obvious to me.
No, What was there, to your knowledge, ever an
An
investigation
investigation.
into how wide the knowledge of bugs, errors and defects pre-prosecution, pre-July 2013, went?
No.
If Mr. Jenkins had withheld from prosecution cases his knowledge of bugs, did you ever advise the instigation of an investigation as to whether such concealment of bugs was known about or facilitated by others?
And being frank on my state of knowledge at the time, one always has to be careful, and I'm sure you'll accept this, Mr. Beer, that, as I termed it earlier, that the clarity of hindsight provides a clear-sightedness, as it were, that you didn't have at the time. But at that time, I don't think it crossed my mind that it went wider than Gareth Jenkins.
That document can come down, thank you. Was any consideration given by you, or to your knowledge by others, as to whether the agreed position that we've just seen reached between you and Mr. Clark was not privileged?
I don't believe we ever had that discussion.
Do you think there ought to have been a discussion as to whether this meeting of minds between prosecutors was not privileged information and ought to have been revealed?
Well, I've already agreed with you about the latter. And if the latter had been the decision I'd arrived at or the advice I gave, then I don't think privilege would have come into it.
So is it, on your understanding, a failure to think about the issue rather than thought being
think,
given but privilege cloaking the answer?
I don't think privilege would have, if I had applied my mind to the fact that Gareth Jenkins' credibility was in issue and his assessment as an expert was in issue, I think I would ultimately have advised that that ought to be disclosed in appropriate cases. I clearly didn't. I can't think now why I didn't. I'd like to say it was a misjudgment, but I'm not even sure there was a judgment. I don't know why. I think we were, if I have to think back and speculate, I think the focus was so geared towards these two new bugs that just slipped through, as it were.
The disclosure that was given on your advice to convicted or some convicted defendants was A, the second sight report, and B, the Helen Rose report.
Yeah.
Neither of those documents revealed anything about Gareth Jenkins' state of knowledge of the two bugs, did they?
No, I accept that. They didn't.
That's a further problem, isn't it? Because you reached a position that Mr. Jenkins was fatally undermined, he breached his duties. The response to which is to disclose two documents, neither of which reveals that information to a defendant.
No, there would have been a gap in anybody's knowledge. I accept that.
There was therefore a well of knowledge sitting below the surface that was not disclosed. And can you help us? Why was that?
I've given the reason. I think the focus was so targeted towards these two new bugs and their impact on affected cases that it's hard to look back and think, how on earth did I miss that? But I think I just missed it. It's as simple as that.
Is it a little worse than that, though? Because if we look at the second sight report, i.e. the thing that was disclosed to convicted or some convicted defendants, Poll 302 9650. This is the second sight report of the 8th of July 2013. If we look at page 5, please. Foot of the page, para 6.4. In the course of our extensive discussions with Post Office over the last 12 months, Post Office has disclosed to Second Sight that in 2011 and 12 it had discovered defects in Horizon Online that had impacted 76 branches. And then it continues with the first defect and the second defect over the page. So the Second Sight report was saying that the disclosure of the bugs came from Post Office,
which I frankly don't understand.
not Gareth Jenkins.
No, but which surprised me because clearly Second Sight, not just Cartwright King, I've read that and I'm well aware of 6.4. And I didn't understand why Second Sight itself was not reporting it was Gareth Jenkins. I'm not criticising them at all for 1 minute, please don't.
So you knew that it was Gareth Jenkins who was said to have made the relevant disclosure.
Yeah.
And therefore, if the report had included that, it would have been a disclosure of his own knowledge of bugs that he hadn't disclosed at the time.
Yeah. Can I say I didn't realise this at the time? I don't think it registered. Obviously, since I've looked at this again. And I've puzzled about 6.4, why it was Second Sight didn't name him, but they didn't. Because it wasn't Post Office. I don't think it was Post Office anyway.
And so the document that is disclosed to some convicted sub-postmasters materially misleads them on this point.
Yeah, but I wouldn't want you to elide the failure to advise disclosure of the fact that it was Gareth Jenkins who brought this to the attention of Second Sight and the fact that Second Sight itself reported Post Office. I don't think anybody made that link.
Thank you, that can come down.
In fact, I know no one made the link and I certainly didn't.
What criminal offences may have been committed by Gareth Jenkins based on the facts as you knew them by the time you were advising in October 2013?
I'm not prepared to speculate about that, and I'm not prepared to speculate because if you're thinking about perjury requires certain conditions which nothing I had seen suggested might be present. And perverting the course of justice and having a tendency to pervert the course of justice with the requisite intent is a particular offence, and I was not prepared to speculate, nor am I now, as to whether he was dishonest or just incompetent.
I asked what criminal offences may have been.
Yeah, well, the maybe would include those two, but as I say, it's speculative on my part because I don't know all the evidence.
So at the time, on the basis of the information that you had, the possible offences that may have been committed by Gareth Jenkins included possibly attempting to pervert the course of justice?
Perverting the course of justice.
Right. Conspiring to pervert the course of justice?
Well, that depends on whether there are two or more parties involved.
And possibly perjury?
Possibly.
Do you agree that nowhere in the Clark advice on Mr. Jenkins, in any subsequent advices written by Mr. Clark that you saw, and nowhere in your advices was the question raised as to whether or not Mr. Jenkins had possibly committed criminal offences?
No.
Why was the question of possible perjury or possibly perverting the course of justice never addressed?
Because I think at that early stage, and in fact with all witnesses who give evidence to civil or criminal courts or indeed in public inquiries, simply because a witness hasn't complied with their duty in this particular case as an expert does not lead inexorably to the conclusion that somebody has committed any of those offences. And again, it would never have crossed my mind that that required a police investigation.
You're ahead of me, Mr. Altman, a little bit, but I'm asking at the moment why we see no consideration of it.
For that reason, it wouldn't have crossed my mind that any police investigation or any consideration of whether he had committed offences was anything A, I was asked to do, or B, I would have volunteered.
Given that the assessment by Mr. Clark was that Mr. Jenkins had known about the bugs in the Horizon system and had failed to reveal them, while simultaneously stating that the Horizon system was robust when he gave evidence in the Seema Misra case. But why was the question of the commission of a possible criminal offence not discussed by anyone?
Well, I think I've answered that, Mr. Beer.
Was it discussed outside the confines of the advices, i.e. in conference or in telephone conversations?
I have no recollection of that.
Was there any discussion about the provision by Mr. Jenkins of statements which had given false information, i.e. the criminal consequences or possible criminal consequences of that?
I have no recollection of that either.
I'm sorry, Mr. Altman. We've heard a lot at this inquiry of I can't remember or I have no recollection. I am taking what you were saying. Well, let me not say that. How am I to take what you were saying? That you simply have no recollection one way or the other?
Yes.
Or you do? Yeah, that's it. Fine.
Yeah, I'm sorry. I know it's rather loose language, but I'm being asked for recollections of conversations which I've never put in writing from getting on for 11 years ago. So
No. I follow that, but in my experience, some people say I have no recollection of that when they mean I don't know one way or the other.
Yeah.
Others use it when they actually mean I don't recollect anything of that kind, but if there had been, I rather think I would remember, if you see what I mean.
I do. Well, it's the former.
It's the former. Thank you.
Mr. Altman, you said today that you think that your approach at the time would have been, this was just one of those occasions, of which there are many, on which a person gives false or inaccurate evidence to a court or an inquiry. Is that right?
Yes.
Did you instigate or advise the instigation of any inquiries or an investigation into whether that was in fact the case or not, i.e. by post office?
No.
Wasn't that important?
It could have been important, but I don't think I don't think that was my role.
You seem to be saying, Mr. Altman, that the fact that a witness has given false evidence in court is just one of those things.
No, I'm not saying that.
Well, can you help us with exactly how you thought about it then? Because we don't see in any of these papers the suggestion that the conclusion that he had given false evidence be revealed to defendants, that the police be called in, that he might have committed a criminal offence, or that anyone should pursue in any way whatsoever the evidence that he gave. It sounded from your answers earlier that lots of people give evidence that's false in court, meant that you just described it as one of those things. Am I wrong to take that?
No, well, I may well have done. I may well have come to the conclusion that, A, that I was not prepared to speculate about what he had done and as I said earlier, why he had done it. But secondly, witnesses can be incompetent and not dishonest. And I was not probably sure at that time that wouldn't be a huge hammer to crack a nut. I just had not been presented, I felt, with sufficient evidence to infer what you seem to be suggesting I should have done.
Nowhere in your general review, would you agree, was any consideration given to the disclosure of the clerk advice about Mr. Jenkins' lack of credibility, your view that Mr. Jenkins was a tainted witness, to the CCRC?
Not at that time, no. But it went to the CCRC, as you know, the general review.
Do you agree that the failure to advise, that the clerk advice and your own opinion, or at least the substance of the conclusions that were reached, ought to have been considered for disclosure?
If we're still talking about Gareth Jenkins' credibility and the
Yes.
assessment of a witness, I've accepted that twice now.
Did you consider the question of making a report to the Attorney General
No,
or the DPP?
no.
And I think you said that it didn't cross your mind to advise to call in the police.
No.
Would you agree that as you didn't advise those things, that that failure contributed to those facts not emerging until the Court of Appeal Criminal Division?
I'm not sure I am prepared to accept that, because the CCRC had the general review, and every word you've quoted at me from it so far, in February 2015.
And so are you suggesting that if the CCRC had wanted to disclose that to defendants, applicants or appellants, it was down to them to do so?
They were able to do it subject to their duties under the Act under which they operate. But the fact is, they had all of that information, and if they had felt that any part of what I had done had been remiss, or there were gaps in the advice I had given, then it was within the gift of the CCRC to conduct their own investigation.
If Mr. Jenkins, as a mainstay of the Horizon system, one of its architects...
Did you say if?
Yes, if Mr. Jenkins, a mainstay of the Horizon system, had concealed some bugs, did the possibility occur to you that more bugs were in his knowledge?
I think not, because I think he was clearly prepared to reveal to Second Sight in a report which he must have realised would be published. Those two bugs in Horizon Online. And so, no, I wasn't aware, and it didn't occur to me that there were many more, certainly not what came out in the Horizon Issues trial.
At no point in Mr. Clark's advices, nor in, I think, yours, is the question of the relevance of the conclusions which you'd reached about Mr. Jenkins addressed through the prism of a possible abuse of process argument considered. Is that right?
Well, I think in general terms I was talking about non-disclosure.
Yes, and so you didn't view this through the different lens of its effect on an abusive process argument.
Well, I did later, but these are different sides of the same coin. If non-disclosure itself can often be the argument which underlines the first limb of abusive process. So it's all much the same argument.
Can we look forward at many, many years to UKGI 301-8137? And this is the Horizon Issues judgment with which you'll be very familiar. And I think you were provided with a copy of this under the embargo provisions at the time that it was still in draft in December 2019 and asked by the Post Office to advise on it, yes? And
I think I was only given certain sections of it.
Oh, I see.
Yeah.
I
wasn't given the whole thing.
Can we look, please, at page 150? And paragraph 508. The absence of Gareth Jenkins, that's the absence of Gareth Jenkins from the Horizon Issues trial. It's entirely a decision of the parties which witnesses they choose to call in any proceedings. The position of one person, however, who did not appear in the Horizon trial must be considered in more detail than would be usual, as the claimants make considerable complaint about this. The person in question is Gareth Jenkins. And then if we go to page 152, please, paragraph 511, when Post Office served their evidence... Sorry, my monitor has...
Gone blank.
Gone blank.
No.
Has yours as well, Mr. Altman?
Yes.
Okay.
I say amazingly, mine hasn't.
So can we pause for 2 minutes, please? we were just looking at paragraph 511. When the Post Office served their evidence of fact, the claimants had asked the Post Office why there was no statement from Mr. Jenkins, whether Mr. Jenkins was available to give evidence, and also whether he was involved in one of a team of what the claimants referred to as the shadow experts. This description was challenged by the Post Office, and the question of shadow experts is addressed further below. No explanation was given for Mr. Jenkins' absence in response to these requests or in evidence in the trial, although it was confirmed that Mr. Jenkins was not one of the team of so-called shadow experts. 512, there the matter might have rested. However, in the Post Office's closing written submissions, an explanation of sorts was for the first time provided. Reading on, this explanation by the Post Office included the following passages in its written submissions. 144, the claimants understandably complain that Mr. Jenkins and the other source of Mr. Godseth's information could have given some of this evidence firsthand. However, 1, taking account of Mr. McLachen's evidence specifically addressed things said or done by Mr. Jenkins in relation to the Misra trial, Post Office was concerned that the Horizon Issues trial could become an investigation of his role in this and other criminal cases. 2, moreover, Post Office was conscious that if it had only adduced first-hand evidence in the trial, it would end up having to call more witnesses than could be accommodated within the trial timetable. And 3, furthermore, so far as Post Office was aware, the relevant parts of Godseth 2 were most likely to be controversial. For example, the Misra trial was a matter of public record. The 4 bugs were covered by contemporaneous documentation, and Post Office had no reason to doubt Fujitsu's account of the documents it held. End quote. Did the fact that the Post Office explained the absence of Mr. Jenkins in this trial as a witness in these terms in any way concern you or surprise you?
I'm not sure which part of the judgment this is and whether these are the parts of the judgment that were sent to me. But what surprises me is, I suppose if that's the question you're asking me, is, and I'm being careful here because this is the commercial litigation, but of which others had conduct, but using him in the background as a shadow expert to inform their case, I suppose, is the key issue.
The reasons 1, 2, and 3 given for not calling him in their closing submissions do not include that Mr. Jenkins had for at least since 2013 been regarded as an unreliable or tainted witness.
Well, I see that here, Mr. Beer. I don't know because I'm just not sufficiently familiar with this judgment, certainly not now, whether that was dealt with anywhere else. But if you're focusing my attention on that particular paragraph, then you're right.
Did you think, when reading this, hold on, there's nothing here about Mr. Jenkins having been assessed by the Post Office to have been a tainted and unreliable witness?
I can't tell you what I thought when I read this.
I take it that you didn't consider it a part of your duty to raise that kind of issue with the Post Office.
Mr. Beer, I can't remember what I thought when I read this paragraph, assuming I did, back in, 2019?
Thank you. Can we go back, please, to the breadth of your terms of reference by looking at poll 406801? And again, this is a copy of your interim review dated the 2nd of August 2013, so a stopping off point towards your general review. And if we look at page 5, please, and paragraphs 11, 12 and 13. you say, I wonder whether non-disclosure by Gareth Jenkins of aspects of the Horizon system is the only potential issue that arises in these cases, or whether there may be other issues which need to fall within the remit of your review. I question whether the sole issue of non-disclosure is too restrictive an approach to take to the review. I've considered the list of issues which were reported to Second Sight in the course of their review by multiple sub-postmasters as being of particular concern. One such concern was, quote, post office investigation and audit teams that have asset recovery or prosecution bias and fail to seek the root cause of reported problems. I've also considered Spot Review SR22, in which, according to the sub-postmaster, the issue was the lack of synchronisation between Post Office and Camelot records for remmed-in scratch cards. Reading on, this case example does not appear to me necessarily to be an issue of non-disclosure, but one that may be argued to relate solely to the proper functioning of the system. The Spot Review leaves the reader with the sense that there remains a dispute between the sub-postmaster and Post Office regarding this case. Has this case and others like it fallen within Cartwright-King's review? And so in those 3 paragraphs, you're saying the review by Cartwright-King is focused on non-disclosure. Reading what Second Sight and some associated documents say, I wonder whether the terms of reference for their review need to be much wider. Agreed?
Yes.
What issues other than non-disclosure did you apprehend or appreciate?
Well, looking at paragraph 12 again, it's almost impossible to put my mind back and, as it were, back engineer what I was thinking about in those paragraphs. But one issue has to be those last 3 lines of paragraph 12. The Post Office was manipulating its prosecutorial function in order to embark on debt recovery.
So that's one example, and I think 13 contains another example,
Yeah.
namely functioning of system
Yeah.
causing losses rather than
Yeah.
disclosure issues.
Yeah.
Where was the issue that you raised in paragraphs 11, 12 and 13 heeded?
Well, there's a question, Mr. Beer, because this was the 2nd of August. Obviously, my terms of reference weren't crystallised until the back end of September. And the review, as you know, or the final review, was dated the 15th of October of that year. I have looked at this and I can't remember what happened in the meantime or whether anybody came back to me, and if so, how, about their views about this or what their responses were.
I mean, to be clear, we're not so much here focusing on the terms of reference for you.
No.
This is you raising issues about the breadth of the Cartwright-King review.
Well, it is that, but I suppose I would have expected if there had been any amendment to this, then I would have seen it in the terms of reference somehow expressed.
Who did you understand to be making decisions about the breadth of the Cartwright-King review?
At that time, Cartwright-King, I suppose.
Did you understand whether civil litigators, i.e. non-criminal lawyers at Bond Dickinson, were having influence over the breadth of the Cartwright-King review?
All I was, forgive me, all I would say about that is that clearly it was Bond Dickinson, particularly Gavin Matthews, who was communicating with me about the terms of reference. So I assume Bond Dickinson had some contribution to that question.
Can we look at what happened as a result of your raising the breadth of the Cartwright-King review? Poll 00298123. And start by page 3, please. 2nd of August, your email sending through both of your documents dated the 2nd of August, including the second of them, the interim review. Yes, which is the document we've just looked at. And then if we scroll up, please. Simon Richardson says that you're away, but that gives you, Susan Crichton, time to discuss with Gavin Matthews and internally the terms of reference. And then scroll up, please. And a bit more. Yes, thank you. This is Mr. Matthews' reply. You're not copied in on any of these.
No.
This is Mr. Matthews' reply, saying he's now had a chance to review your interim review of Cartwright King's process, i.e. the document we've just read, and set out mine and Simon Richardson's comments and suggestions for future action. It's clearly good news that the current limited Cartwright King process if adopted is broadly fine. And then 2, he raises the issue of whether the current review is too narrow. See paragraphs 11, 12 and 13, which I've just read to you. He references the list of issues in the second site report and spot review 22 as examples of other issues which may need to fall within the ambit of Cartwright King's review. Whilst this should be put to Cartwright King, my own view is that it may be very difficult for Cartwright King to expand the review on issues on which second site have failed to come to any conclusion. And then scroll down, please. Our advice is 3, Bond Dickinson, Andy Parsons should sit down with Brian Altman to walk him through the spot review process and the second site report so that he can understand the impact of his review on the civil side.
Sorry, so we're on 3, forgive me, I was
Yes.
reading 1 and 2.
So we read 1 and 2
Yeah,
of the first part and then 3 of the second part.
right. Yeah, well, that didn't happen.
Were the ramifications of widening the scope of the Cartwright King discussed with you?
No, I don't think they were.
Was the fact that it might impact on the civil side, i.e. on civil claims, raised with you?
No.
Were you ever told that that issue, broadening out the limited Cartwright King process, needed to be treated with some circumspection?
You mean the what's expressed there in point 3?
Yes.
No.
In your interim review, we've seen that you were alive to the fact that Second Sight was raising questions which were unanswered,
Yeah.
may need following up, hence your paragraphs 11, 12 and 13.
Yeah.
But here the Bond Dickinson seem to think otherwise, don't they?
It appears to be so, yeah.
Did you meet Andy Parsons, as is suggested here, that there should be a sit-down with you to walk through the Second Sight report so you can understand the impact on the civil side?
What's the date of this email, please?
If we scroll to the top,
Is it 5th of
it's
August?
5th of August.
Well, the only way I can answer that, and if it was contemporaneous, is you've got my work log, I think, for that period. And I think you'll find the first conference I ever had, and it's work record 1, was the 9th of
The 9th of September.
Yeah.
So outside of that,
Well, beyond it, yeah.
I'm sorry,
The 9th of September postdates this email by several weeks.
yes. So outside of that, what is contemplated here, that the civil lawyers sitting down with you,
Oh, a civil lawyer. Yeah, Andy Parsons, you mean?
yes,
If I had such a conference, it would be reflected in my work record.
and so that didn't happen.
I have no recollection of anything like that happening, I'm afraid, no.
So what happened to the point that you raised in your paragraphs 11, 12 and 13 about the broadening of the Cartwright King review?
I don't know.
What happened when you realised, as you must have done, that your suggestions had not been followed.
Again, at this distance in time, I just can't remember.
Did you ever get a sense of a lurking difficulty here, that the things that you were suggesting ought to occur for the purposes of the criminal law were causing the civil lawyers some concern?
Well, this is the thing, Mr. Beer. No. I cannot remember anybody saying to me, Brian, if you advise this, this is going to have an impact on civil liability. I don't recall anybody saying that to me. Because if I had, there would only have been one answer.
Which would have been?
That I am afraid that the advice I give you on disclosure will have no bearing on your exposure to civil liability.
But at all events, what was contemplated by the civil lawyers here, namely a sit-down and a walk-through of the impact of your activity on the civil side, did not occur,
No.
to your recollection?
On this occasion, I'm going to go further and say it didn't happen.
Thank you. Can I turn to my third topic then, the cut-off date
Yep.
of the 1st of January 2010,
Yes.
and in particular, Seema Misra's case.
Yep.
This document can come down, thank you. Now, I think by the time you came to write your general review in October 2013, you knew that Seema Misra had been convicted of a criminal offences in October 2010.
Yeah, but she had also, of course, pleaded guilty to offences of false accounting in 2009.
Yes. And by the time you came to write your general review in October 2013, you were aware, I think you'll agree, of a wide range of material that undermined the Post Office's key witness in the case against her, Gareth Jenkins.
Yes.
And by the time of your general review of October 2013, you knew that it was Gareth Jenkins who had given live oral evidence against Seema Misra.
Yes.
And most significantly, you were in possession of the 15th of July Simon Clarke advice.
Yes.
On reading the Clarke advice, you didn't disagree with the conclusions that Mr. Jenkins' conduct was in breach of duties to the court as an expert, and that his credibility had been fatally flawed. Indeed, you agreed with them.
I did.
And you didn't disagree with the advice that there were repercussions for past and present prosecutions and repercussions for past convictions. Indeed, you agreed with them.
Yes.
The Clarke advice was amongst the papers that you received, a very significant document, wasn't it?
It was significant advice, yes.
It had obvious implications, didn't it, for the safety of convictions in which Gareth Jenkins had given trials in which Gareth Jenkins had given evidence, whether in a witness statement or oral evidence.
It had significance for, in terms of disclosure and a possible impact in some cases on safety, yes.
It wasn't restricted to that, was it, though? It also opened up the proper functioning of the system, namely the disclosure of bugs by the Post Office.
Yes.
You agree that the information contained in the advice was disclosable on the basis that the Post Office had allowed, I'm going to use a neutral expression there, had allowed misleading evidence to be adduced in a number of trials, in written statements, and in one case through live evidence, promoting the safety of the Horizon system and even allowing a defendant to be convicted on the back of that disclosure failure?
Well, I think it's the same question you're asking me, Mr. Beer, about what I've already accepted, that his credibility should have been considered for disclosure and disclosed with the benefit of hindsight.
And I'm asking it specifically now through the lens of the Seema Misra case.
Well, the Seema Misra case is slightly more complicated, I'm afraid, because at that time, as I said earlier, the focus was on Horizon Online, her branch was affected, or the theft count was, if my memory serves me, between 2005 and 2008, so it was a legacy Horizon issue. And I accept that when we came to the appeals all those years later, the landscape was completely different. But at that stage, I think one of the problems was that, and perhaps taking a naive view, that the two new bugs, and I only knew about three, I think, at that time, Calendar Square or Falkirk, which was a legacy bug, and the two new bugs in Horizon Online, which had been revealed to Second Sight and which they had reported on, I felt could not be material in her case.
And what I'm going to explore over the next, I think, half an hour or so is the change of view.
Yeah.
Between what the position you took in mid to late 2013
Yeah.
and then the position adopted in the Court of Appeal 7 or so years later.
Yeah.
So by the conference on the 9th of September 2013, you knew that Mr. Jenkins was the sole expert witness for the prosecution in Seema Misra's trial, because I think you'd read the transcripts by then.
I think, it's hard to recollect exactly what I had seen, but there's no question I had seen some transcripts because the conference...
I'll try and help you on this.
Right.
Let's look at poll 406485. This is one of two notes of the conference on the 9th of September 2013.
Yep.
And you are recorded as opening the conference by confirming that you had read through all 5 of the ring binders delivered by Bond Dickinson. And then if we go to page 3, please. And the second paragraph, you're recorded as saying that you required a full transcript of day 6 of Seema Misra's case. The copying had only copied every other page,
Yeah.
and that was going to be sent on to you. So by this time, you had got into the detail of Seema Misra's case.
I certainly read it, yeah.
Yes. Can we see, according to the other version of the minutes, what you said or were recorded as having said about Seema Misra's case? Poll 00139866. Notes of the meeting with you on the 9th of September, and you'll see who was present.
I've only seen this note in the past few days.
I'll take it slowly then. Again, a similar start, QC, that's you, said he had read all of the papers. And then if we go to page 6, please. And about a third to a half of the way down where it says QC. If that can be highlighted. QC, this is you. Misra concerned. Pre-Horizon Online case. Issues were detailed, as I've seen. She went to prison. Jenkins gave evidence. Training and Horizon issues. Professor McLachlan, much of it hypothesis. That is a case slipping through the net. Susan commented that she'd applied for mediation. You say, how are we going to deal with it if she comes forward and says similar? Susan Crichton says, either review all pre-2010 cases or we do nothing and wait for them to come forwards. You say, next problem, what disclosed? That's Roderick Williams. We will always have people who want to go back, and if we do, trying to prove a negative. you're recorded as saying, can't avoid the question. Provisional view, a sensible date to adopt, but can't avoid the possibility that miserers may crawl out of the woodwork. Deal with on a case-by-case basis, unless someone states cut-off is unreasonable. Does this record of this conference fairly reflect your view that the cut-off date of the 1st of January 2010 was sensible to adopt, but that there was a possibility that miserers might crawl out of the woodwork?
As I say, I've seen this conference note for the first time in the last 7 days, and I didn't have an opportunity to look at it all those years ago. But I've no reason to think that it's inaccurate.
And just scrolling up a little bit, where it says slipping through the net, can you see that?
Yeah.
That the Misra case might be a case slipping through the net. Was that an acknowledgement that Mrs. Misra's case fell outside the parameters of the review that you approved?
I mean, on one interpretation, and if if the note is accurate, answer yes.
Was the cut-off date a principled decision rather than an attempt to close down complaints and prevent the floodgates from opening?
Not from my perspective.
Did you gain any impression that from the post office's perspective, the cut-off date of the 1st of January wasn't a principled decision, but instead an attempt to close complaints down and prevent the floodgates from opening?
I mean, I dealt with this, you'll recall, in my general review, and I made comments in various places about Cartwright King keeping their mind open.
I'm going to come, if it helps,
Well,
to the general review at the moment.
I'm sure you will, but this was always my thinking. To answer your question, I remember making some comments about Simon Clarke's view about the cut-off date, and I had some views that some of the factors he brought to bear on that decision were nothing I could support and did support.
And we'll see that in a moment when we look at the general review. You say some of his logic was not supported.
Yeah, I'm sorry, I know I'm jumping ahead, but to answer your direct question, I don't recall getting the impression that Post Office saw it in the way that you suggest they might have done.
So can we take our second break? At that point, please, I'm going to come back to this meeting after the break. Until 25 past, please.
You read my mind, Mr. Beer.
Thank you, sir. 25 past. Good afternoon, sir. Can we go back, please, Mr. Altman, to the note of the conference of the 9th of September 2013, poll 0013 9866. And page 7, please. Sorry, page 6. About halfway down. Thank you. And your recording as saying, in relation, I think, to Miss Misra's case, that it is a case slipping through the net. And then Susan Crichton replied, or she commented, that that's Miss Misra, had applied for mediation. Yes? Would you understand that to mean, or to be a suggestion, that she wasn't slipping through the net entirely, because after all, Mrs. Misra had applied to be a party to the mediation?
I'm not sure I would have, at least at that time, have linked the two, my comment and hers.
You subsequently advised against the inclusion of Mrs. Misra in the mediation scheme, didn't you?
Yes.
And so to the extent that this is a suggestion by Susan Crichton that she wouldn't slip through the net, your subsequent advice had the effect of meaning that she would slip through the net and the mediation scheme would not save her.
Well, you could infer that from this, but I suspect at the time that I was thinking about Mrs. Misra and the mediation, my view was principled, that clearly I was concerned that she was a case slipping through the net, but my approach to mediation, not just for Mrs. Misra, although she was the name that was put to me, I don't remember any other names of any other postmasters being put to me other than hers. But mine was a principled approach to it.
But you would agree that despite that principled approach, it would have the effect of excluding Mrs. Misra from the mediation and thereby obtaining any information
Yes.
through that route.
I'm harsh though it may appear and unpalatable after all of these years, that is and was the effect of it.
And if we read further on in the attendance note, if we scroll down, please. You say can't avoid the question, and then reading on to where I stopped off, you're recorded as saying, so any individual for 2005, I was prosecuted and pleaded guilty. And then you said, recorded as saying that Mrs. Misra was unique.
Yeah.
Did you regard her case as being unique?
Well, there are two words there, which I take it this is Martin Smith's note that he recorded, which I didn't see at the time. If I use the word unique, I'm prepared to accept I might have done, but whether it was simply a single word response like that or there was more to what I said, I can't tell after all of these years. Then it could have related to the fact that she was the only case in which Gareth Jenkins had given evidence.
And what was the significance of that? What were the consequences of that?
Well, I don't, the trouble is in the context of a note like this, I can't tell you. But the consequences were that I suppose she wouldn't know that Gareth Jenkins had revealed what he had to Second Sight. I suppose looking back with hindsight after all these years. But the trouble is looking at this note and the way it flows. And if we carry on, perhaps.
Yes, if we go over the page, please.
If you would, because I think there's
7.
more context to this. I just wonder whether it was part of the conversation about the mediation.
What, the fact that she was unique was a...
Well, Mr. Beer, you're asking me about a single word in a document I've only seen this week, which I didn't see at the time. And I'm doing my best with what's in front of me. I don't know.
Shall we look at what's about a third of the way down the page there?
Yeah.
It's recorded that Gavin Matthews asked Misra, should we apologise?
Yeah.
And you replied, it is recorded, I wouldn't.
Yes.
Can you recall the question of apologising to Seema Misra arising?
Well, if Mr. Smith's note is accurate, then it did. And again, if Mr. Smith's note is accurate, I must have said something along those lines. Whether it would have simply been a 2 or 3 word response, I doubt very much.
Looking back now, can you think why you would have advised not to apologise
Yes.
to Seema Misra?
Yes, I can. Because for 2 reasons. It wasn't just about the fact that she had been convicted of theft, but she had also pleaded guilty to several offences of false accounting in 2009, which at that time, on what I understood, could not be related to any issues with Gareth Jenkins. And therefore, if Mrs. Misra was admitted to the mediation, as a point of principle, I just couldn't begin to understand why in some form of quasi-civil process, Post Office wanted to ride both horses at the same time. Here they were saying, this conviction is safe, and those pleas of guilty are safe. And at the same time, we want to engage, or we could engage in mediation with her. I just didn't understand the idea of apologising to somebody, Mrs. Misra, as it was understood at that time, and at the same time potentially talking about financial compensation. So it was a principal point. I'm afraid her pleas of guilty, the convictions arising out of those pleas of guilty and the conviction for theft were, like everybody else who were convicted claimants, were unoverturned at that point. And it was for the Court of Appeal to disturb those convictions, not the mediation scheme.
You address these issues in your general advice. Can we turn that up, please? Poll 406581.
6-5.
81. Poll 406581.
We had 6803, I think, before.
Yes, we've obviously got it
Never mind,
twice.
it's the same document.
And can we look at page 23, please?
Page 23.
Yes.
Yeah.
And from this point, page 23 onwards, under the cross-heading Nature and Scope of Cartwright-King's review, you, in broad terms, in summary, address the scope of the review,
Yeah.
looking at geographical extent, temporal extent, and other issues, correct?
Yes.
And then if we go, so if we look at 58, the nature and scope of the review was defined in Simon Clarke's 8th of July advice, which coincided with the day of publication of Second Sight's report. The advice was that cases affected, including Royal Mail Group cases pre-separation, and the areas of concern were the proper functioning of Horizon training and customer support. And then if we go, please, to over the page, and I'm afraid it's going to be necessary to read quite a bit of this, from 61 onwards, you address the temporal scope of the review. There was also consideration to the start date of the review. Horizon Online was migrated into all post offices between January and September 2010. Thus, the advice given was that the start date for the review process should be the 1st of January 2010. That's to say the earliest date for the Horizon Online rollout. Mr. Clarke advised in an advising on this date, he had in mind issues of proportionality, resourcing, transparency, and the post office's reputation. Just stopping there, were they proper or all proper reasons to focus on when deciding whether to look for material that may disclose a miscarriage of justice?
I think I dealt with this, didn't I, in the general review, where I said that they weren't proper factors.
Yes, and so the four factors set out there,
Yeah.
proportionality, resourcing, transparency, and reputation,
Well,
which of them were not proper factors?
Well, if all four were designed to identify the 1st of January as the start date, as it were, for the review, all of them.
So that none of them is a proper factor.
I didn't think so, and I'm sure, I think I said that a little earlier, Mr. Beer, at 63 and onwards, I think I deal with
You
this.
come on to address some of them.
Yeah, or some of them, but I didn't think any of them applied, and certainly not Post Office's reputation.
No. So in deciding how far back to look on whether exists material
Yeah.
relevant to a miscarriage of justice, the Post Office's reputation is not something to bring into account.
It was nothing to bring into account, and that's why I said what I did.
You record in 62, Simon Clarke's view was that any sub-postmasters prosecuted under the former Horizon regime would have served any sentence of imprisonment or performed any unpaid work requirement or paid a fine, and at all events, the publicity from Second Sight's report will put those defendants on notice. And in 63, you record that the appendices in the Second Sight report are posted on the website. And then line 3, you say, I'm afraid I do not see those who have served their sentences, etc., should for that reason be excluded from the review. They have an interest if their conviction was unsafe. And there must be people who fall within the current review who've been released from their sentences or had non-custodial sentences imposed on them. So you're saying that that element of Simon Clarke's reasoning, that all these people have done their time, is illogical and can't be relied on.
Yeah, I mean, with respect to Simon Clarke, I frankly didn't understand those points. And then, as you'll see, I dealt in that final sentence with two other of the factors which I'd listed above, resourcing and the reputation.
Beside the point, correct. And then you continue, when I queried the rationale behind the cut-off date, I was told and entirely accept that prior to each branch rollout, a cash audit was done so that each branch balanced. I advised in conference, and repeat here, although Post Office has no positive duty to seek out individuals before the 1st of January 2010 start date for a review of their case, nonetheless, if Post Office was approached, it would need to make ad hoc case-specific decisions about the need for disclosure. The Misra case is an example of the case I have in mind. Although she was tried in October 2010, allegation related to events between 2005 and 2008, long before the rollout of Horizon Online. However, the issues raised in the case, which were made late by the defendant in one or more defence statements, were very similar to those generally being raised currently in the Horizon Online system. She was eventually to claim that the approximate £75,000 deficit in her office was due to a technical error or her own incompetence, having initially sought to blame employees. There's no information that Mrs. Misra is now seeking to appeal her conviction, although she is seeking to participate in the mediation process. 67, there are currently 12 or 13 conviction case applicants. And then over the page, you've considered Second Sight's inquiry. You note it is not time limited. The definition of horizon that Second Sight relied upon is widely drawn. And you note in the last 3 lines of that paragraph, the spot reviews, or several of them, involve horizon issues predating 2010 rollout of Horizon Online. And then 70, despite the open-fronted nature of Second Sight's inquiry, it's important to recognise that Second Sight has only so far discovered and reported on 2 Horizon defects, respectively occurring in 2010, which you assume to be a defect with Horizon Online, and 2011. And then your conclusion, in my judgment, the 1st of January 2010 start date for Cartwright King's review is both a logical and practicable approach to take. That's not to say if a case predating the Horizon Online rollout presents itself, that CK should exclude it from consideration. There may be cases that raise genuine, thorny technical issues, which are not unrelated to issues concerning Horizon Online, which, after all, is next generation Horizon. If they arise, they'll have to be dealt with as required on a piecemeal basis. If it got to the stage where the floodgates of pre-Horizon Online cases began to open, then the Post Office and Cartwright King will have to remain alive to the possibility of commencing a subsidiary review. So you say that the cut-off date is logical and practicable. Dealing with practicability first, why was it practicable?
I think it was practicable because the bugs which had been revealed to Second Sight and reported by them in the interim review were accessible in the sense that they were more recent. And second, I have in the back of my mind that there was some problem in going back to legacy Horizon and understanding what might have happened with that system.
Where did you get that understanding from?
I am sure I knew about that. I know I don't say it here, but I'm sure I knew about that.
What was the nature of the thing that you knew about?
Simply, I think that it was the system archived or not live anymore, something like that.
In terms of the logic, you say that it is a logical approach to take. In saying that it was the logical approach to take, did you take as your starting point the assumption that there were no bugs in the old Horizon system?
No, I didn't take that as an assumption because I knew that there was one, which was Calendar Square. But I suppose it was looking at the two new bugs which had come to light. Calendar Square or Falkirk had been litigated in the course of Mrs. Misra's trial in 2010 and was to that extent in the public domain. These were two new bugs. And they were two new bugs in Horizon Online. And that came online and was migrated to branches from the 1st or by the 1st of January 2010. And that was the logic to it.
The balance of 71 is essentially a way of saying that if any other cases crawl out of the woodwork, isn't it?
Yeah.
We'll face them when they arise.
Well, I think that's a rather harsh judgment, Mr. Beer, because I think what I'm really saying is I'm saying to Cartwright King and Post Office for that matter, you must remain alive to the possibility of commencing a subsidiary review. So, to the extent that I did use that term in the course of the 9th of September meeting, I mean, this document is the 15th of October, so it's 5 or 6 weeks on, and my thinking had moved on. And I recognised, and I wanted Post Office and Cartwright King to recognise, that if there is a legacy Horizon system problem, then you're going to have to potentially consider commencing a subsidiary review. That's what I meant by it.
Can we look at a stepping off point between the 9th of September conference and the 15th of October general review? Namely an email of the 3rd of October, poll 0006 6825. This is an attendance note from Martin Smith of Cartwright King of the 3rd of October 2013, of a conversation that he had with Gavin Matthews of Bond Dickinson. So this is after your September the 9th conference, but before your 15th of October general review.
Yeah.
The summary telephone call Gavin Matthews, he's spoken to Brian Altman QC. Detail telephone call Gavin Matthews, he's spoken to Brian Altman QC. Mediation cases can go on separate spreadsheets. So far as date is concerned, understand why the 1st of January 2010, but on the basis no bugs prior to then on old system. He advises only need to review Horizon Online cases since that date. Martin Smith says he's not sure that is correct. HB currently looking at Misra transcript to see what Gareth Jenkins said.
HB, Harry Bowyer?
Probably.
Yeah.
Think it likely to contain a reference to the Misra bug. Gavin Matthews suggests that you may well have advised on the basis of an incorrect assumption. Martin Smith said he would call tomorrow. And then the rest is about something else.
Right.
Are they right that you advised on the basis of an incorrect assumption that there were no relevant bugs pre-Horizon Online?
I can't see that's possible. I can't see that's possible because by the 3rd of October, as you pointed out earlier, I'd read transcripts from the Misra trial.
Did either of them raise their belief that you were advising on an incorrect basis with you?
No, I saw this as part of the disclosure to me. Frankly, I can't remember if it's in my original bundle or the additional documents, but it doesn't matter. I was totally unaware of it.
And so Mr. Smith did not call you the next day, to the extent that that's a reference to him going to call you the next day?
Well, I don't want to say no without looking at my work log, which would only be fair. the next
Be the 4th.
4th of October. Yeah. So I had a conference call with Gavin Matthews, Cartwright King and Post Office for half an hour.
On the 4th.
On the 4th, but as you all know, that related to the scope of the review, and that is recited in the general review. But I don't recall anybody suggesting to me you've misunderstood.
Thank you, that can come down. Sitting here today, do you stand by the advice that the correct cut-off date was the 1st of January 2010?
Yes, on the basis of my understanding at the time, which did, in my mind, it must have included, I knew about the Calendar Square bug in Legacy, and that was the only bug I knew about in Legacy. Yes, I do.
And the corollary of which is that the Post Office should do nothing in relation to sub-postmasters convicted before that date, and instead wait to see whether they came forwards.
Yes, and that was based on mixed fact and law. The law has never been post-conviction that a prosecutor has to go out and search for cases which may be unsafe on the basis of little or no information. And that was confirmed, actually, not at that time, but I'd always understood that to be the position. That was confirmed in the Supreme Court in the case of Nunn in 2014.
Had you not given consideration at this point to the fact that you regarded Mr. Jenkins as an unreliable witness? He had been a cornerstone of the case against Seema Misra, and that at least in her case, there ought to have been such disclosure.
5th time of agreeing with you, Mr. Peer. I've made that plain. Yes, I can see that.
What accounts for the failure?
If I cast my mind back, I think the only thing that would have gone through it is the fact that the failure by him was to identify in her trial bugs in Horizon Online, which would not have impacted.
You told us today that your concern about admitting people like Seema Misra to the mediation scheme was that they remained convicted defendants. The mediation scheme could do nothing about that.
Yes.
Only the CACD could.
Yes.
Can we look, please, at poll 406485? This is the other note of the conference on the 9th of September.
Yes.
And if we scroll down, please. And keep going. And keep going. Thank you, keep going.
Which page do you want, Mr. Beer?
I think it's on the second page. Stop there. Yes, it's the on the screen, it's the second paragraph from the top. No, sorry, the wrong paragraph. If we keep reading, please. Keep going on the scrolling. Yeah, there. Third paragraph. There was then a discussion in relation to the overlap between the intended mediation process and criminal cases. Andrew Parsons reported the current position in relation to the mediation process and how it was intended to work. Individuals currently being prosecuted are not eligible, though individuals who've previously been convicted are eligible for the scheme. And you're recorded as saying that you advised considerable caution in relation to mediation cases involving previously convicted individuals. Seema Misra has already indicated an indication to be within the scheme. The concern is that lawyers acting for those individuals may be using the scheme to obtain information they would not normally be entitled to in order to pursue an appeal. Is that, so far as you can recall, an accurate summary of your advice as to why convicted individuals should not be admitted to the scheme?
That wasn't my advice at all. My advice was that there should be caution in relation to the mediation cases, and that was for the reasons I've already given. The way this is written may suggest this was my advice. It wasn't. The concern that lawyers acting for those individuals may be using the scheme to obtain information they wouldn't normally be entitled to was Cartwright King's or post offices. It wasn't my concern, as I made clear in subsequent paragraphs in the advice I later gave.
This doesn't record as the reason for not admitting sub-postmasters who have been convicted to mediation.
No.
That they remained convicted.
No.
It's recorded as you expressing a concern about lawyers getting information to which their clients are not entitled.
No, I'm sorry, but that is a misreading, or it's an unfortunate juxtaposition of two sentences. The first was my advice. This one doesn't say BA said. This one said the concern is that. And I made that clear in my witness statement. And if you go to the general review, you will find me expressing, perhaps more accurately than this is prepared to do, that the concern, in fact, I think I used the words understandable, but that the concern was Cartwright King's. And if my memory serves me, I think you'll find that in paragraph 129 of the general review.
And so this paragraph in the conference note, which I think you did have an opportunity to settle at the time, didn't you?
No, I don't think I did.
You weren't sent this to
I'm not saying
approve
I
or
wasn't
amend.
sent it, but I don't think I was sent it to approve. And frankly, if I'd have looked at it, obviously, all these years after, one can go through it with a fine-tooth comb as we are. But even if I had, I don't think I'd have done that or looked at it with any particular, unfortunately, using the word concern. But I can tell you categorically that second sentence was not any concern I advised on. It was not my concern, it was theirs.
And so this should either be a new paragraph after the end of the words "the scheme,"
Well,
and beginning with the concern,
Well,
and
yes.
it should read Cartwright King held a concern.
If I was writing it and I'd applied my mind to it, if you think that this was me saying it, I'm afraid, Mr. B, you're very wrong. I was not. And as I say, I made that perfectly clear when you come to look. As I say, I think it's paragraph 129 of the general review. Because this was an ongoing theme. And I think 129 is where I recite the conference we've just been looking at of the 4th of October. It's the same thing. And and if you look in that paragraph, I think I'm right in saying it's 129, you'll see I set out exactly the same words, almost, that it was Cartwright King's concern.
Did you say to them, that's an improper concern to hold?
I think what I said is what appears, again, in somebody else's note in the paragraphs that follow.
Were you concerned at all about the need for the post office or Cartwright King to take control over what Second Sight was disclosing in the course of the mediation process?
Yes, it was about supervision, and it was about controlling the information disclosed or being disseminated to individuals who were within that scheme, not being blindsided by evidence that they were not aware of, and auditing the information, which, in my experience, is no different to what any prosecuting authority does in any disclosure process. And again, actually, Martin Smith's note on this occasion sets it out pretty clearly, because I had said, I think it may be page, I can't remember now, page 8, possibly page 6, where he noted that I said that there should be a sharing of the information and it should all be recorded by Cartwright King. That's what I was talking about.
You weren't concerned that Cartwright King or the post office should control what Second Sight was disclosing in the course of the mediation process?
I felt there was a risk, as I recall it, that Second Sight, this was an uncontrolled environment. So I felt there was a risk. And that's why I gave the advice I did. This wasn't about not disclosing. This was simply advice about supervise what's happening so that you know what's going out of the door. It was as simple as that. A record, an audit trail, you know what's being disclosed.
Can we look, please, at poll 0033 7202? This is an email from you to Gavin Matthews about a fortnight after the conference. The first page concerns the terms of reference. Can we look at the second page, please? Regarding the conference note, I think that's the conference note for the 9th of September, it accords with my recollection, except in a case of a couple of matters listed above. And then as to the final paragraph of the draft conference note, I did advise that Cartwright King needed to rethink the terms of the letter they're sending out. And then I also recall advising, one, there was no positive duty to seek out individuals before the 1st of January 2010, but if the Post Office was approached, it would need to make case-specific decisions on disclosure. And secondly, you recall advising about the need for the Post Office and Cartwright King to take control over what Second Sight was disclosing in the mediation process. Why was it necessary for Cartwright King to take control over what Second Sight was disclosing?
Well, for the reasons I've already given, that I wanted to ensure that Cartwright King, as Post Office's external solicitors, understood what material was going out to postmasters.
That's a slightly different issue, isn't it? They should have visibility of what is disclosed.
No, it's the same thing. I spoke in terms, I used the term control and supervision pretty interchangeably. It was, I wanted them, and I've already said this, what Second Sight, I think, or what I understood was doing, was uncontrolled. I wanted Cartwright King to know what was being disclosed.
So it's 1 o'clock. Might we take the lunch break? And
Yes.
10 to 2, please.
10 to 2 is a truncation of the transcriber's lunch break in any event. How do you foresee this afternoon going, Mr. Beer?
I envisage going until about 20 past 3, and then some questions from call participants.
And so we need to have 10 minutes less for lunch, do we?
I'm afraid so.
All right, then 10 to 2.
Thank you, sir.